The salesperson promised the product would last a lifetime, but the fine print says otherwise. Can the seller just erase a warranty with legal language? Well, under the UCC, the answer is sometimes. So let's talk about warranty disclaimers, what works, what doesn't, and why it matters when a promise has been made. A disclaimer is a statement that a particular warranty does not apply. So what can be disclaimed and how a disclaimer is made is really going to depend on what type of warranty we are dealing with. So expressed warranties, we can disclaim or exclude any warranties, express warranties, or there can be some limitations on what will be warranted. First of all, the seller doesn't need to make any sort of promises or affirmations of fact, right? We just don't have to do that as a seller. Describing the goods, do we really need a description of goods? They don't have to use a sample or a model. Sometimes it's really hard not to because you want to sell your product. You got to say something about it. You have to describe it in some fashion. Maybe you don't actually have to show a model, but hey, if there's a floor model, that helps even more. But one way is to not even do those things, but that's just not going to happen, right? How are folks going to purchase products? The UCC has some requirements if a seller is going to disclaim express warranties. Need to use specific and unambiguous wording in the written sales contract that eliminates any warranty. The reason or the goal for this is to protect the buyer. Protect the buyer from any surprises. You got a salesperson making statements and all of a sudden, yeah, we didn't agree to that, right? We got a disclaimer. It's in the fine print. Nope, it has to be specific, has to be ambiguous, and it should be where the buyer will see it. An express warranty disclaimer may look like this. If XYZ has a contract, XYZ company's entire warranty is printed below. Any statements made by any agent or salesperson are disclaimed and form no part of this contract. This language is a valid disclaimer if a sales rep had made certain statements to get a buyer to buy a product. However, if we have written express warranties, especially if these written express warranties are in a written contract, it's impossible to disclaim. So if a seller includes an express warranty in the sales contract and a disclaimer, the disclaimer is going to be invalid. What if the express warranty is in another document, say like a brochure? If that's the case, and then we have a sales contract that has a disclaimer, the disclaimer is going to be void if it would unfairly surprise the buyer. So it has to be, well, written and conspicuous. Otherwise, the buyer is going to be surprised by that if they're reading it in a brochure that it comes with a particular express warranty, such as a product description. Implied warranties, they can also be completely excluded or limited in some way. Common disclaimers, generally implied warranties of merchantability and implied warranties of fitness for a particular purpose are disclaimed by expressions like sold as is, right? Or with all faults is another common one. And there's some other similar expressions, but as long as those other similar expressions would be common understanding to both of the parties, not just one of the parties. So, but as is, I think we all have seen that, sold as is. That means there's not going to be any implied warranties in that good. There are some specific requirements for implied warranty disclaimers if we are talking about the warranty regarding fitness for a particular purpose. It must be in writing. It must be conspicuous. It does not need the word fitness. That's not required. An example of this would be there are no warranties that extend beyond the description on the face thereof. So this particular disclaimer is relying on the express description. So there is an express warranty here, and it's the description that's on the face. So the packaging, the description on a crate, on a box. So the description on its face. So there's nothing beyond that. Merchantability. If a seller wants to disclaim the warranty of merchantability, must specifically use the word merchantability in that disclaimer. Does not need to be in writing, but if it is, it must be conspicuous. Key points about disclaimers is buyer's awareness. Disclaimers must call the buyer's attention to the fact that there are no implied warranties here. And I'm going to know when we're talking about the sale of consumer goods, some states actually prohibit a seller from disclaiming implied warranties at all. What if the buyer actually inspects the goods before entering into a contract? Will the implied warranty still attach? If the buyer examines goods before entering the contract or refuses to inspect goods, there is no implied warranty with respect to defects that a reasonable examination would reveal. And I want to note that refusing, in some cases, a seller might demand inspection of goods and the buyer then declines. But in either case, the seller is going to remain liable for hidden defects that ordinary inspection would not reveal, depending on the buyer's skill and method of examination. So taking an example, we have Robin, an auto mechanic, who's purchasing a car. What would you expect of an auto mechanic? Should the auto mechanic be able to discover defects that a non-expert buyer would not be expected to find? So it's driven by the circumstances of the situation to determine what defects an inspection should reveal. And of course, it's going to depend on who that buyer is. So the circumstances are going to determine. So that is our discussion on warranties, completes the series of videos on warranties. And I'll see you in the next section.